Lesson: Global privacy standards and their impact on U.S. companies. The landscape of global privacy standards presents a complex web of regulations and guidelines that significantly impact U.S. companies. As organizations increasingly operate across borders, understanding and complying with international privacy standards becomes essential. The General Data Protection Regulation of the European Union, the Personal Information Protection and Electronic Documents Act of Canada, and the California Consumer Privacy Act in the United States are just a few examples of prominent standards that shape how data is handled, processed, and protected. Each of these regulations imposes different requirements and expectations, and U.S. companies must navigate these intricacies to maintain compliance and avoid hefty fines. One of the most influential privacy standards worldwide is the GDPR, which applies to all companies processing the personal data of EU residents, regardless of the company's location. This regulation emphasizes transparency, data minimization, and user consent, requiring companies to implement robust data protection measures. For U.S. companies, complying with the GDPR involves several actionable steps: conducting data protection impact assessments, appointing a data protection officer, and maintaining records of processing activities. DPIAs help companies identify potential risks in their data processing activities and implement measures to mitigate these risks. Appointing a DPO, particularly for companies that handle large volumes of personal data, ensures that there is a dedicated individual responsible for overseeing data protection strategies and compliance efforts. To illustrate the practical application of GDPR compliance, consider the case of Facebook, which faced significant scrutiny and fines for its handling of user data. By failing to obtain explicit consent for data processing and not adequately informing users of how their data would be used, Facebook violated GDPR principles, resulting in a fine of 50 million euros imposed by the French Data Protection Authority. This case underscores the importance for U.S. companies to prioritize transparency and user consent in their data handling practices. In addition to GDPR, U.S. companies must also consider the implications of PIPEDA when dealing with Canadian consumers' data. PIPEDA requires businesses to obtain consent before collecting, using, or disclosing personal information, and mandates that organizations implement appropriate security measures to safeguard this information. To comply with PIPEDA, companies can adopt the 10 principles outlined in the legislation, such as accountability, limiting collection, and ensuring accuracy. A practical tool for companies is the development of a privacy management program, which can help organizations systematically address PIPEDA's requirements and integrate privacy into their operations. Cross-border data transfers pose another significant challenge for U.S. companies. The GDPR, in particular, imposes strict rules on transferring personal data outside the EU. Companies must ensure that adequate safeguards are in place, such as standard contractual clauses or binding corporate rules, to legally transfer data. SCCs are pre-approved model contracts that guarantee data protection during transfers, while BCRs are internal codes of conduct adhered to by multinational organizations. Implementing these mechanisms requires a detailed understanding of the legal and technical requirements involved. For example, Microsoft has successfully implemented BCRs, allowing it to transfer data globally while maintaining compliance with the GDPR. The California Consumer Privacy Act serves as a domestic example of stringent privacy regulation that U.S. companies must navigate. Although it primarily affects California residents, its implications extend nationwide, as businesses that operate in California or handle data of California residents must comply. The CCPA grants consumers rights such as the ability to access, delete, and opt out of the sale of their personal information. To comply, companies need to implement mechanisms that enable consumers to exercise these rights, such as creating user-friendly privacy dashboards and updating privacy policies to reflect CCPA requirements. The impact of global privacy standards extends beyond compliance obligations. They also offer strategic advantages for companies. By prioritizing privacy, companies can build trust with consumers, differentiate themselves from competitors, and reduce the risk of data breaches and associated costs. For example, Apple has leveraged its strong privacy stance as a competitive advantage, emphasizing data protection as a core value in its marketing campaigns. This approach has resonated with consumers, contributing to Apple's reputation as a privacy-conscious brand. To effectively navigate the complex landscape of global privacy standards, U.S. companies can benefit from adopting privacy frameworks and best practices. The National Institute of Standards and Technology Privacy Framework provides a comprehensive tool for managing privacy risks. It offers a structured approach to identify, assess, and manage privacy risks, aligning privacy strategies with business objectives. By using the NIST privacy framework, companies can enhance their privacy programs, facilitate compliance with various regulations, and strengthen their overall data governance practices. Training and awareness programs are also crucial for fostering a privacy-conscious organizational culture. Employees at all levels must understand their roles and responsibilities in protecting personal data and be equipped with the knowledge to identify and respond to potential privacy risks. Regular training sessions, workshops, and e-learning modules can help reinforce privacy principles and ensure that employees remain informed about evolving regulations and best practices. In conclusion, global privacy standards significantly impact U.S. companies, requiring them to navigate a complex web of regulations to ensure compliance and protect consumer data. By understanding the specific requirements of regulations such as the GDPR, PIPEDA, and CCPA, companies can implement actionable strategies to manage privacy risks and maintain consumer trust. Practical tools and frameworks, such as DPIAs, SECs, and the NIST privacy framework, offer valuable guidance for companies seeking to enhance their privacy practices. Moreover, by fostering a privacy-conscious culture through training and awareness programs, companies can proactively address privacy challenges and leverage privacy as a competitive advantage in the global market.